Hi everyone, my name is Alexander Zalivako, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. I would discuss today sanctions and the way they may restrict or affect persons' access to courts. And more specifically, we will talk about the general rights of access to courts and the way they may or may not be affected by sanctions. Then we will talk about the issues which arise as a matter of law and as a practical matter with respect to securing legal representations in connection with court proceedings. And finally, we will touch about the satisfaction of legal awards and judgments. Two diametrically opposite issues arise in connection with the question whether a person subject to blocking sanctions has access to courts. The first issue is that this person cannot have access to courts. The logic here being that the possible judgment given in favor of such a person is inconsistent with the blocking statute, which prohibits any financial resources or funds being made available to such a person, and in general requires that all funds and economic resources of such a person are blocked. And on this basis, the argument is made that the access to courts which contributes to the funds or economic resources being available to the blocked person shall be restricted. The opposite argument, now made by a blocked person, would be that as his or her access to courts are restricted as a result of blocking sanctions, then such person shall be permitted to disregard the relevant jurisdiction clause in the contract providing for the jurisdiction of those courts which proceedings are affected by sanctions, and should be permitted to litigate in, typically, his home jurisdiction. With respect to both of these points, it is worth to remember that, for example, as far at least the European Union is concerned, the Treaty on European Union recognizes the Charter of Fundamental Rights, having the same value as the treaties themselves. And then Article 47 of the Charter effectively sets out that the right to effective remedy and the access to court is one of those fundamental rights which can be restricted in second instances, but require a very careful and balanced restrictions. And obviously those restrictions cannot affect the core of the rights, being the access to courts as such. Similar principles are recognized in other jurisdictions. For example, UK would also recognize the right of access to courts as a fundamental core of the legal system, which can be restricted by an act of parliament, but any such restriction shall be construed restrictively and only minimum necessary to implement the relevant provisions shall be accorded. It's interesting, though, to consider how this, so accordingly, in principle, every jurisdiction will not recognize that sanctions completely prohibit the relevant blocked person to have access to courts, and on this basis, blocked persons should be permitted to issue proceedings or to defend proceedings in the courts of those jurisdictions where they are subject to the sanctions block. It's interesting to pause for a second and think how this right of a blocked person to pursue or defend proceedings are coexisting with the non-claims provisions, which are present in many sanctions statutes, which in essence do not allow a blocked person to raise any proceedings and to bring any claims which can be based on any restrictions resulting from sanctions. The way these two principles seem to coexist is that the courts would be looking at whether the relevant claim is based on the restrictions resulting from sanctions, whether it's based on something else, and most commonly something else would be pre-existing obligations, pre-existing dispute, which was not affected by the sanctions in which the courts can legitimately adjudicate. Having decided with the in-principle questions whether a blocked person can have an access to courts, another point to consider is whether this in-principle right can be practically implemented. And from the practical implementation perspective, another key question to respond is whether a person has a right to secure his representation in the relevant court proceedings. Many current disputes are complex, and the right of access to courts would be in vain if the relevant party cannot be properly represented by competent counsel. From the perspective of representation, an issue arises whether this representation and this type of services as such would be restricted by blocking statute themselves, which typically provides provision of funds or economic resources. Again, taking into account the overriding and fundamental principle of effective remedy as being the core of most of the legal systems, as well as the argument that legal representation as such should not be classified as an economic resource because it's not something which can be exchanged for funds. The response to the question would be that legal representation in the court proceedings should not be restricted by blocking statutes themselves. Nevertheless, a corollary to legal services is certainly the ability of a party to pay for the legal services, and the payments which would be necessary in connection with any court proceedings, being the payments of various fees, being the payments of fees to the legal counsel, as well as various payments, for example, with respect to security for costs, undertaken for damages, and this type of payments would be indeed restricted by blocking statute because they would result in the transfer of funds, typically emanating from the blocking person or the agent of such blocking person. So with respect to this transfer of funds, indeed, the restrictions would apply, and we would discuss in a minute how this could be effectively addressed. The position in the United States is a bit different with respect to the matter. The blocking statute in the United States does not refer to the prohibition to provide economic resources, but uses a broader language, saying that any funds, goods, or services may not be provided to a blocked person, and arguably legal services is a service. In addition to this, the US system does not operate the developed concept of fundamental human rights as the European system or the UK system. Nevertheless, ultimately, the issue is addressed in the United States as well, because typically any sanctions regime will have a general license whereby OFAC will provide for the opportunity to provide legal services in connection with the court proceedings, and the same license would typically provide the opportunity to pay for those court proceedings, although with the fresh money, meaning with the money of the blocked person which are not located within the US jurisdiction and which is not blocked. To the extent the person would like to use the blocked funds for the purpose of pursuing any proceedings in the US, a separate license would be required, and that again would be granted in very limited circumstances. So the ability to be able to process payments when pursuing or starting the court proceedings in a jurisdiction where the person is subject to blocked would be of key importance, because certainly failure to make payments on time may adversely affect the course of proceedings. Here, an important point to note that these payments would be subject to blocking sanctions, and accordingly, to the extent they arrive within the jurisdiction where the relevant sanctions apply, they would be blocked by the relevant banks. And for that reason, typically the application for licenses would be required in the jurisdictions. Some jurisdictions, like for example UK, issue so-called general licenses, in essence following the example of the United States, and those permit certain payments within budgets and for certain purposes authorized in those licenses. They're typically limited by time, so it's important to monitor both the amounts which were spent in reliance on those licenses, as well as the question whether the relevant general licenses were indeed extended upon their expiry. The European Union does not operate the same concept of general licenses. Furthermore, for the time being, there is no passporting of national licenses. So to the extent that the payment passes through several jurisdictions, which could very well be the case if, for example, the account of a blocked person is located in one jurisdiction of the European Union, but that bank uses another bank located in a different jurisdiction, the corresponding bank, it may very well be the case that separate licenses to process a payment would be necessary in each of those jurisdictions. Nevertheless, for the time being, the authorities are very well aware of the importance of the right of legal representation and in general issue the relevant licenses on time and with no particular issues. Another point to consider when starting litigation or defending a litigation in the jurisdiction of the blocked sanctions is the travel ban restrictions, which may or may not apply to the various parties which need to appear as witnesses. Typically, the blocked person himself or herself would need to appear as a witness. If that's an individual involved in the litigation, for a company which is involved in the litigation, which is a blocked person, there may be certain officers of the company who are also blocked persons. They need to appear as witnesses in the process of the litigation. That's an important consideration. Many of these issues have been practically addressed by way of relevant courts permitting the video participation of the relevant witnesses. Nevertheless, there are certain jurisdictions where in-person presence in court is necessary, and this may create practical problems. Another practical issue of pursuing or defending proceedings in the jurisdiction where a person is subject to block sanctions are the internal in-house rules and restrictions of law firms or other persons which may need to be involved in a complex litigation, like experts, for example. They may not be willing to act on behalf of the blocked person. And here, whilst in many jurisdictions, there would be a cab rank rule equivalence, whereby the person shall be allocated a counsel in connection with the defense of the proceedings or pursuit of the proceedings. The exact scope of those rules is not very certain in many jurisdictions, and accordingly, there may be a practical problem of securing the proper representation. The final question to consider is the satisfaction of judgments issue, because it would serve no purpose to pursue proceedings if ultimately you get a judgment which cannot be satisfied. And here, the question would depend on whether the judgment is given for or against the blocked person. In general terms, a judgment given against a blocked person is enforceable and may be satisfied, except that certainly to the extent this leads to the use of the frozen assets, this satisfaction would need to be authorized by the relevant national competent authorities. So they would need to check that indeed the relevant payment is made to satisfy the judgment or an arbitral award. And this will be an additional consideration which will make it more difficult to satisfy the judgment against the blocked assets. But in principle, the system functions in the way that to the extent a judgment is given against a blocked person, and to the extent the creditor wishes to satisfy this judgment out of the frozen assets within the jurisdiction, his rights should not be affected. Conversely, with respect to the judgment given in favor of the blocked person, The enforcement becomes more difficult because the satisfaction of the judgment is certainly leading to the provision of funds to such blocked person to the extent the relevant judgment shall be satisfied in cash. Arguably, judgment given in different form, except for declaratory judgment, for example, or conditional entry judgment, may lead to the question of whether economic resources are provided to the person. So here, in general terms, I think it's less clear how and when the judgment may be satisfied. Nevertheless, the regulation provides for the opportunity of the debtor under such judgment to make the payment to the frozen accounts of the blocked person, which is in general consistent with the principle that the blocking sanctions are not aimed at expropriation of the assets or are not aimed at general deprivation of rights of the blocked person, and is more of a temporary measure and at restricting the access to his assets. So in this sense, the payment of the judgment into the blocked account is a reasonable compromise between the necessity to comply with the sanctions regime and the respect of those rights of the blocked person, which he still possesses. I hope that you found this presentation useful, and thank you very much for watching.